Okay. Good afternoon, ladies and gentlemen. I hope you all had a very nice lunch. We have been on a long journey, and our journey here together is almost over, and you will begin your work of recalling the facts and applying them to the law as the judge will instruct you. There's been a lot of information in this case. You received 72 items of evidence from the state, one from our case, and that's a lot of evidence. I hope you take the time to patiently and laboriously go through each and every piece of evidence that the state has provided to you, because the answers are there. Truth is truth. Truth doesn't waver and vacillate. People do. People do because of influences, because of memories, because of relationships. And it's very important that you consider those items that will conflict a person's testimony in determining whether they were telling you the truth, the whole truth, and nothing but the truth. Now, we began our journey going back to September 12th, 2015, in Ocala on Pine Street at a nightclub called Cloud 9. And we saw the exhibits. The first two exhibits that the state brought you were overhead pictures of Cloud 9, Pine Street. One was a further view up and one was a closer view, but they were both overhead. And that was to give you a sense of where things were happening at the club that night. And I want to thank the state for doing that. Now, the officer that you heard from, the first witness, they were conducting a traffic stop. And I believe that traffic stop was right along this little side street. And one officer was a canine, and there were other officers there. And they had pulled this car over, and they were conducting a stop. You can see from this exhibit how close they were to the nightclub. The building just to the left of this street is what we've been referring to as Murphy's Oyster Bar. And the building just to the left of that in the photograph is Cloud 9. And we have the parking lot going around the entire building, and the south side of the building is to the left of that building. And we know that there were hundreds of people there that evening. It was a big event. We've heard about the Virgo birthdays. They got in for free. We also heard that people were coming and they were standing outside in line waiting to get in. Some people were paying hundreds of dollars to get in to the club that night. We heard about where various different cars were parked. A Mercedes that was parked just to the southeast corner of the building, and another truck, a Dodge, I believe it was, that was parked just to the south of the club. We've come to be very familiar with this area. The first view that we got of that evening was Officer Rodriguez's testimony. It was powerful testimony. All the on-scene officers in this case witnessed an event that they're not used to. They'd never witnessed before. Officer Rodriguez, when the shots were heard, the officers immediately ran towards the gunfire, just like a firefighter would run to a fire in a building. They ran. That's their job, to put themselves in front for safety, for people. Officer Rodriguez ran back, around the back of the club. And the reason why I'm going through this with you is because his body cam video was placed into evidence. And it's an important piece of evidence. All the videos in this case are important. When you watch that video and play it, stop it, rewind it, go over it, make sure that you are satisfied what you see in that video. When he comes around the back of Cloud 9, the back door is open and people are inside and you can see them. Light is coming out from the building. There's very little light out there except for certain street lamps that might be giving light. But for the most part, it is a very dark area. Now, Officer Rodriguez has a flashlight. And when he comes around the southwest portion of Cloud 9, his camera will focus on an individual that I would ask you to pay attention to. This individual is walking to a car. He gets into a car. Observe what that person is wearing. That person is wearing a black polo shirt and red basketball shorts. That person, we believe, is Herbert Waldo. Now, in addition, you will see Gerald Shaw in one of the videos. And he runs up to an officer and he proceeds to tell him, I just saw 4 persons get into a dark colored car in the back parking lot and take off, and they were the shooters. Now, he doesn't talk very specifically about much else in that particular contact he had with law enforcement at that moment. Law enforcement were tending to the wounded, trying to get EMS, trying to get other officers there, trying to control the scene. As they've all told you, it was chaotic, not something they were used to. After the shooting, everyone had scattered, and for a few moments, it was very quiet in front of Cloud 9. And then all the people started pouring back. They started coming back. And you heard about the radio traffic and the white Mitsubishi and a high-speed chase. And I would submit to you that if you look on the videos, you will see a white Mitsubishi. And it actually pulls up in front of Cloud 9 in order to take somebody to the hospital. That car was not part of anybody who was perpetrating a crime. Now, once the officers were on scene, we had the sheriff's office come and Ocala Police Department come, and the evidence text came. And you will see an Ocala Police Department officer walking through one of the videos with tape, with a camera, and they begin taping off the area that will be called the crime scene. The whole club is actually the crime scene, but there are specific parts. We have an area down here in Murphy's Oyster Bar, which is the southeast side of that building, and that's where one of the individuals who was wounded is there on the ground. She was wounded in her leg. I believe it was Tamia Wadley. And she is receiving assistance from the officers, trying to calm her down. She's in extreme pain. She's screaming, it hurts, it hurts, it hurts. We have other officers arriving. As you now know, this is where Miss Robinson was found on the ground, where officers made valiant attempts to save her life, and EMS came and she had passed, and they went on to help the others who had been wounded. The front of this club, the arch there, that's where Dee Dee Kendrick and her brother Nate Kendrick wound up being taken after they had fallen from their wounds. We have Dontarius Bartley, who was down on the ground with a wound. Davenus Blunt was shot in the leg. The question here is to decide if the state has proven beyond and to the exclusion of every reasonable doubt that the people that they've charged with the crime committed the crime. I would submit to you that they have not. Now, we know that there were shell casings found, and we know that 2 bullets were recovered by Dr. Lavezzi, the medical examiner, from Miss Robinson, and that a fragment of a jacket from a bullet was located at the southeast fascia of this building. Those 3 items of evidence, based on Ms. Draga's testimony, were similar, that she could say from the rifling, were fired from the same firearm. Now the casings, however, there were 4, 4, and 13. Ms. Draga, the firearms expert, told you that those 21 casings, 4 were fired from one gun, 4 were fired from another, and 13 were fired from a third gun. But she could not tell you that the 3 projectiles, the 2 that came from Dr. Lavezzi and the 1 that Kathleen Schmidt from the Marion County Sheriff's Office uncovered when she was doing her evidence work here at the southeast corner, she could not tell you that those 3 items in any way matched up to the casings. That is an example of reasonable doubt. We know that when Ms. Schmidt did her trajectory rods, she didn't use lasers, which are normally used.
Objection, argued facts not evidence.
Overruled.
We know that there was no angle of line. We know that she found marks that were in the front of the club that the state has referred to as strike marks. But I believe on cross-examination, she agreed that they could have been made by something else. It could be that those marks represent ricochet strike marks from ammunition hitting them, or it could be that they were made by heavy equipment being moved into the club or some other metal item on the ground. We don't know. Ladies and gentlemen, that is reasonable doubt. Now, the witnesses. Dontarius Bartley, one of the individuals that were shot, he testified that he'd had quite a bit to drink, that he was in the club but in the bathroom when a fight broke out. So he didn't see what was going on with the fight. He didn't see who was fighting. As he was leaving the club, he headed north. So that would have been towards Murphy's Oyster Bar. He heard gunshots, and he was shot in the back. He doesn't know Michael Eugene Smith. He doesn't know anyone else, and he can't tell you how or who shot him. Ebony Yeomans. Ebony Yeomans is a friend of Miss Kendrick's, and she knows Nate. And she's very close, and she would want to help her friend. She said she had never seen Michael Smith before that evening, except in the parking lot. She said he was standing with Quan. Well, you saw in the video the commotion out front that you can look at, Miss Hall's video. There is a person out there that is wearing a tank top and red colored shorts, basketball shorts. And we admitted this picture of our client being at the front door. We don't know if he's at the front door after the fight takes place or before the fight takes place. It's the state's position that this picture occurred after the fight. It's our position it could have occurred before the fight. It's for you to decide the facts. Now, was Michael Smith inside the club? You heard from Mr. Counsel, the security guard, said he was roving that night. And he crossed paths with Michael as he was going into the bathroom, either going in or coming out. You recollect what he said. Michael may have been going in when he was coming out, or vice versa. I don't remember, there was so much information. But he remembers what Michael was wearing. He remembers that Michael was wearing what he's wearing in that picture, a tank top and red shorts. Why do I bring this up to you? Because Dee Dee Kendrick told you that Michael Smith was wearing a black shirt inside the club. I submit to you, that was Herbert Welcome. There was no fight between Eugene Smith and Nate that evening. If there was, Nathaniel Kendrick would have testified to it. Now, Ebony Yeomans talked about Michael Smith was standing outside on the other side of a vehicle from Quan. But you heard from someone else that they thought they saw Mike standing on the same side as Quan. You heard a witness tell you that Quan reached into the car, but they don't know what, if anything, he retrieved from the car. These are all inconsistencies. These are reasonable doubt. These are facts that show reasonable doubt. Now, Melissa Hall. Melissa Hall testified, and rely on your own recollection, but I thought I heard her tell us that the person she was identifying as Michael Smith was wearing a t-shirt, long white t-shirt with writing on it. And that he had a gun in his waistband. Let your own recollection be your guide, but that's what I thought she told us. Michael Smith this morning was in that video, but he's still wearing the tank top and the red shorts. And he's moving around. And that video, it's not the best. It's quite bad, actually. It's moving all over the place. But yes, you can stop it. You can rewind it. You can look at it. Be thorough. Take the time to go through it. You see Javon Collins and this person with the t-shirt on with the writing doing something. We don't know what they're doing, but they're doing something. Maybe they're passing a gun. Maybe the person with the t-shirt was giving a gun to Mr. Collins. I don't know. I don't think it's apparent in the video. That would be speculation. Again, the lack of evidence. It may be nothing. They may have just been there mulling around, having a good time, while other people were talking, moving about, some leaving, some coming, some going, some arguing. Now, someone suggested that my client could have changed his clothes or changed his t-shirt. We've heard from several witnesses who describe what they were identifying as my client. But these witnesses all had my client dressed differently. Let's talk about Gerald Shaw. Gerald Shaw came to the club that night, didn't get in, was in the parking lot. When the chaos and the shooting start, and after it's finished, he takes his observations and he goes to a police officer and he reports them. I see 4 guys getting into a car and leaving the scene. They're the shooters. Later, he gives a statement to Detective Newbanks. And you heard Detective Newbanks on the stand, and I asked him, did Mr. Shaw tell you that the person was wearing an orange polo shirt? Yes. And orange pants? Yes. He described the person here in court as my client wearing red shorts and a black hoodie. He's also been known to say that he saw somebody with red shorts and a black polo shirt. These are inconsistencies in their testimony which raise reasonable doubt. I would submit to you, at no time was my client wearing the clothing that Mr. Shaw described to you. Mr. Shaw thinks he saw my client because, why? because after the event, sometime after the event, he was on Facebook. He was shown photographs. He was given help in identifying the person he came in here and said was my client, but it wasn't my client. How do we know this? My client did have red shorts, but he had a tank top on. Now, one witness, Nathaniel Kendrick, said that my client, Mr. Smith, was out towards 441 when he was shooting. I submit to you, that was not my client. That was someone else. Mr. Kendrick didn't make this identification until sometime after he came out of a coma. And his sister went to talk to him and showed him some photographs. Again, this is reasonable doubt. I'm sure we all wish that the video camera that's on the southeast corner of this building was working. It would have made things a lot easier. Now, you have the testimony of Keuna Oates and her friend Dee Dee Webster. They came to Cloud 9 that night together. And she gets a tag number and she gives it to police. She doesn't know Michael Smith. Dee Dee Webster doesn't know Michael Smith. We have Lateria Blocker, who told you that she was around that back door that you see in Officer Rodriguez's videotape. She came out the back door and came out around the back side, and that's when she says she sees who she identifies in that silver truck. But then she says she sees an individual walk up to a girl, and he's wiping off, which she testified to was a firearm. And that person then gives that item to the girl. She gets in a car with another girl, and they leave. That person was identified as China White, Bird, Joshua Ring. Not my client. Now, Lateria Blocker knows of Michael Smith. She didn't see Mr. Smith in the club, and she didn't see my client with Mr. Barrow or Mr. King. She was still inside the club when the gunshots went off. She told us the parking lot was very dark, and I think you would all agree with that. She never saw Mr. Smith with a gun. She only saw the person who we later came to find out was China White with a gun. Now, Javon Collins. Javon Collins is good friends with people, and he knows my client. I'm not so close to him. He said he saw my client in the club with a black polo shirt. But I showed him the picture that I put into evidence, and he was stunned. He was stopped in his tracks. He was very surprised. Why? Because obviously he was trying to bait and switch. He he was trying to say that my client was wearing the black shirt and the red shorts. But we heard from Herbert Welcome, he was wearing a black shirt and red shorts. And I'm sure neither of them are aware of the videos that we have. Now, I know that people have gotten on the stand and have told you, I would never forget that face. But they did not pick out my client that night, the next night, not until weeks later, not until after having influence from their friends, Facebook, other media. Quite frankly, I don't know where you would put a gun in basketball shorts and a tank top like the one he was wearing. It wasn't one of these big, huge, tent-like shirts. It was pretty fitting. Kiara Scott, he didn't see my client out there when the shooting started. So when you get through all of these inconsistencies, there's more reasonable doubt, and so much reasonable doubt that you can't be sure who was in that parking lot. Now, the state would have you believe that somehow there was some kind of conspiracy going on. We don't have any conversations other than a person shouting outside the club and hearing those shouts. We don't know what other people are thinking or where they're going. We know that Kiara Scott is holding somebody back. But again, that's for you to decide the facts of that part of the case. My job here is to represent Michael Eugene Smith, a young man who happened to be at the club that night, not really dressed for the club, as Mr. Counsel would say, kind of flitting around from person to person, being social, like you heard from one of the witnesses. He socializes with everybody. Now, when you get to go back to deliberate, you will have a packet of jury instructions. They're very lengthy and quite complicated to a certain extent if you've never gone through an experience like this. We've all had experience, and I was getting confused looking at them. You will be asked to select a foreperson. You can take those jury instructions and separate them out on the table to try to give them some organization so that you can go through them with some uniformity. Talk about each person that's involved, each count to each defendant, and look at the facts from my client and what you decide he did or didn't do. And the same for the other defendants. Mr. Gorley did a very good job this morning going through the various defense instructions that you will receive. Independent act. If you think my client may have been there on the periphery, but not intending to do any harm and not in control of anyone's actions, but someone else decides to do something and hurt someone, that's where the independent act comes in. And you will have that to look at. A principal is someone who does something in furtherance, aids, abets, or counsels somebody in a crime. We usually talk about that in the sense of if there's a robbery and there's a driver, the driver's on the hook for whatever happens inside the place that's being robbed. Just as if he were inside committing the robbery along with the other person. This is not a situation where there are principals. This is a group of people. There's been no plan divulged to you. Nothing. It's just one upset person outside with his friends. What happens? Where those guns came from? Who was firing the shots? I can't tell you. The state seems to believe that it's my client and two others. Eyewitness identification. That is a very slippery slope, especially when you have people in our society today. We have access to so much electronic media and so much influence from people. This whole last year, all we've been hearing about is how the Russians interfered with our election. Now, that's how pervasive media is in our society. And communicating to our friends who we think did something may not be correct. They're not forensic scientists. They're not police officers. They're not experts. They are people. They are impassioned. They are upset. They want justice. Justice is not based on sympathy and anger. Justice is based on looking at the evidence as if each one of you were scientists, looking at the facts, going back over the testimony. And when you review the testimony of the witnesses, be prepared. You may all have your own version of what you heard. You will have to discuss what you heard. Come to a consensus, an agreement. And if you can't, you can't. That's how our justice system works. But like Mr. Gorley said, if you make your own decision and you each decide what the evidence was, that's all we can ask you to do. Now, my client chose not to take the stand, and you will receive an instruction on that. The instruction will tell you that my client exercised a constitutional right, and under no circumstances are you to infer anything from that or hold anything against him because he made that choice. There are many reasons why someone chooses not to take a stand. Maybe they have a speech impediment and they're very poor speakers and you can't understand them. Maybe they don't speak English well. Maybe they have things going on, they don't want to be subject to cross-examination. But that doesn't matter. If they choose not to take the stand, that's all you can look to is our Constitution protects them. And you have to give them and follow the law that says they're allowed to do that. And you shouldn't infer anything from their choice. Now, there's several pieces of evidence that, like I said, 72 pieces of evidence state prepared a very nice exhibit for you. This book of many photographs. I would submit to you that this is nice, and it's kind of helpful. But the videotapes are what I would ask you to look at and comb through thoroughly. These are an aid to those videotapes. Now, the person who Mr. Shaw identified, I think he was saying the person was wearing dark clothing at one time. Then he said he had on a black hoodie. He said he had orange clothing on. He said one person had a faded mohawk. And if he was referring to my client, you look in the photograph and determine if that's a mohawk to you. I would submit Mr. Shaw misidentified my client. Now, when I was a young child, we had this game that we played called telephone. And someone on one end of the phone line would be given a phrase, and it would be whispered to the next person, and the next person, and the next person, and the next person, all the way down the line. And then the last person in the line would repeat what they were told by the person next to them. More often than not, it was not the same phrase that was originally told to the first person. The color of truth stays the same. It doesn't waver and vacillate. You can have a reasonable doubt by the conflict of the evidence, lack of evidence. We as lawyers get to be very creative with evidence in closing. We try to tie the loose strings together for you to help you make sense of the testimony in a case. But sometimes you can't tie all those loose strings together, and the evidence just keeps wavering and vacillating because there's too many contradictions. There's no contradiction about the people that were shot. I have a daughter.
Object is to relevance.
We all feel sympathy for Miss Robinson and her family. And I'm going to ask you to do the hardest thing you can. Put that sympathy aside. Look at the evidence objectively and decide. For over 200 years, ladies and gentlemen, we have relied on our jury system and the laws that have been given to us by our legislature. We have three branches of government. We have the legislature that write the laws. We have the state who applies the laws, and we have the judiciary that interprets the laws. And it would be a disservice and an injustice not to follow the law. If any of us, if I have said anything or done anything that offended you, I apologize. Please, if I've said something that doesn't agree with what you believe you heard from that stand or reviewing the evidence, rely on your own recollection. I would say that for all the lawyers. What we say in closing argument is just that. It's argument. It's not evidence. It's how we are interpreting the facts, just like the state interprets the facts and the evidence. The law, we're all going to say the same thing to you. The law is the law is the law. The judge will give you the law in a packet, and you will apply that law to the facts as you recollect them. And reasonable doubt will require you to render a verdict of not guilty for Michael Smith. I believe there is overwhelming reasonable doubt in this case as to his involvement. There are too many contradictions. There's too little evidence. And I trust in the system that we have, and I believe in the system that we have. And I know each and every one of you will do in that jury room, what you've done here in this courtroom, work hard, listen hard, and render a true and fair verdict. Thank you, ladies and gentlemen.
Mr. Bankerwitz.
Ladies and gentlemen of our jury, you folks in the back row who've sustained now for a number of weeks, we thank you very much. We thank you for your interest. We thank you for taking notes and for sitting here attentively, listening and watching everything in this case. For the most part, I agree with my co-counsel that there are more contradictions in this case than there are facts. I'm going to try to track the witnesses as I saw them and as they applied specifically to Mr. King. Again, there's no forensics, nothing to link him forensically to any of these acts or actions. No fingerprints, no DNA, no guns. We've got a bunch of casings from apparently 3 guns. We've got the video at the club, which really isn't very helpful to anyone. It would have been nice if that back camera had been working, where it showed people coming out the back door, but it wasn't. We have Mr. Burney. Mr. Burney was in the club, saw Gary King in the club. At the time, specifically when the shots rang out, his testimony was Gary King was in the club. He said that Gary King was not a shooter, could not have been a shooter, because he was in the club. He knows Gary King. He's known him for a long time. He knows him from the club scene, basically. And he could not have been a shooter. Mr. Bartley, a victim, doesn't know Gary King, no identification of Gary King, no identification of anybody, essentially. Mr. Blunt didn't see who shot him. Miss Wadley didn't see who fired the guns. Ms. Blocker says that she saw Gary King and Mr. Barrow leaving in a truck. Well, this is contradicted. Totally. The only thing she's consistent with is that she saw Joshua Rainey with a gun. and handing the gun off to someone else, two young ladies in a car. Melissa Hall, who took the video, the cell phone video, probably the best video of any of them. And again, she was there taking the video and never saw Gary King. He's not on the video. She knows Gary King. She's indicated that she saw Kira Scott, Mr. Barrow, and Mr. Smith go into the truck, dark truck, and leave. Not Gary King. The only evidence is that Gary King went and got into a black Kia by himself and left the area. Then we have Ebony Yeomans. She was right there when the shooting took place, right out in front of the club. She saw Gary King. He did not have a gun, and he was not a shooter. She has more connection to the Kendrick family than pretty much anyone in the case, other than the Kendricks themselves. She used to date Nathaniel Kendrick. You would think if she could help him out, she would. But no, she says Gary King was not a shooter. Dee Dee Webster. Again, knows Gary King. Did not see Gary King shooting or with a gun. Saw the situation. The only thing she saw was him trying to calm down Mr. Barrow. Gary King was trying to be a peacemaker that night. Tried to break up the fight in the club. He tried to break up the argument between Nathaniel Kendrick and Mr. Barrow. That's a peacemaker. Miss Oates got the tag number for the Kia. She was standing in the area. Says the shots were from the side of the club. Gary King was in the front of the club. She did not see Gary shooting or with a weapon. One of the most telling witnesses is Danielle Kendrick, Nathaniel Kendrick's own sister, who was standing there right next to her brother, near her brother, when the shots started. Heard the argument between her brother and Mr. Barrow. But again, Gary King was not even there, she says. Says that her own brother told Mr. Barrow to go ahead and shoot him. But again, as it applies to Gary King, he wasn't even there by her testimony. And this contradicts her brother, who says that there was the three of them, 1, 2, 3, just like they're sitting here. And they all fired. Not according to his own sister. Then we have Nathaniel Kendrick, or the Raging Bull, or whatever it was. He's contradicted by his sister, by his former girlfriend. He's got 6 prior felony convictions. Try to remember his attitude when he was testifying. How he slouched down and put his head back and smiled and winked, and he thought this whole thing was a joke. That's not a credible witness, and that's something that the jury instructions will tell you you must look at in determining credibility. He's contradicted by everyone in the case. And one factor that you must look at, or I submit to you you should look at, is his identification in the hospital soon after this incident. He does not pick Gary King out of the lineup. He doesn't identify Gary King as doing anything or even being there until 3 months ago when we took his deposition. And the detective who showed him the photos testified that, in fact, he was lucid, he knew what he was doing, he was speaking with him, and if he hadn't been in that type of condition, he would not have shown him the lineup or conducted an interview. So if the state comes up here later and says, well, he was out of it, he was on drugs and morphine and this and that and this and that, that's contradicted by the evidence of the detective who took the statement. Wayne Counsel, the bouncer. Says that he saw suspects, what he described as suspects, running to the side of the building. Gary King wasn't with him. He knows Gary King. Never saw Gary King with a gun. Gary was trying to be a peacemaker in the fight in the bar. Gary King was trying to calm things down outside. The only person he saw, he says, with a gun was Mr. Barrow. And that Gary was trying to calm everything down. I ask you a question. Why would he try to calm things down and then turn around and shoot somebody? It's absurd. One of the things the court's going to tell you is use your common sense. That doesn't make any sense. Person who's there trying to make some sense out of everything and keep everybody calm so nobody gets hurt turns into the actual shooter. That's absurd. Absolutely absurd. Last but not least, Mr. Shaw. Well, again, attitude. He agrees with Nathaniel Kendrick because he's got a relationship with the Kendrick family and also with Benitra Robinson's family. He says he saw my client get into a dark, or the shooters get into a dark Malibu. That's a Chevrolet, mid-size Chevrolet car. My client was in a Kia, everybody else was in a truck. So who did he see get in the Malibu? Those are the people he identifies as the shooters. Says Gary King had colorful clothing on. Other witnesses testified he had a green outfit on. Mr. Shaw says that he had blues, pinks, yellows, just almost outrageous colors on him, not according to other witnesses. Says he's short. My recollection was 5'2" to 5'4", colorful clothing, and the gold teeth. Well, that description, unfortunately, fits Mr. Collins. He was wearing bright colors that night. He has all gold teeth, and he's about 5'4". So who is he identifying? Again, he says 4 people got into a dark Malibu. These were the shooters. Yet we know from other evidence and other witnesses that Gary King left alone in a black Kia. He looked at photos. He looked at Facebook. He was given people's faces to look at before he made his identifications in this case. That is improper. Mr. Collins. Yes, he's friends with the defendants. So what? He says when the shot started, the first thing he did was look at Gary King, who was ducking behind a car, just like he did. I would submit to you he's more of an independent witness than anything else. He said he actually saw Gary King in a green outfit, standing in front of the club. He had no gun, he was not a shooter, and he didn't have a mohawk haircut, which Mr. Shaw says one of the shooters did. Garrett Scott, the person who was supposedly helping or trying to keep Mr. Barrow out of this, says he saw Gary King, he knows Gary King. Gary King did not have a gun. Mr. Welcome, Gary King's best friend, but he never even made it into the club that night. He was walking up when all this happened. He was there standing with Gary King. No gun, did not fire a gun. The law in this case, as will be read to you by the court, the key is reasonable doubt. And what is a reasonable doubt? You've got to make that determination. But in this case, the substantial weight of reasonable doubt is unbelievable. The contradictions are reasonable doubts. Each and every one of them creates a reasonable doubt. And there are so many contradictions, even among family members, the Kendricks. They contradict each other. So, under reasonable doubt, you must look at the evidence, conflicts in the evidence, and the lack of evidence. I submit to you, you have all of those aspects of reasonable doubt, especially the conflicts in the evidence and the testimony. Credibility of witnesses. Again, the contradictions in the evidence affect the credibility of the witnesses. Contradictions in Mr. Shaw's testimony, in Mr. Kendrick's testimony, who are really the only two people who say that all three of these people shot at Mr. Kendrick. Yet every other witness, civilian witness, contradicts them. That's reasonable doubt. Gary King had no reason to shoot anybody. Why? He wasn't involved in the fight. He was trying to be a peacemaker. He was trying to calm things down. Why would he turn around and shoot somebody? Doesn't make any sense. Common sense is a key in this case and every criminal case. Using your common sense and looking at all the evidence, looking at all the witnesses, and then making your determination. And as Ms. Hawthorne said to you, this is not a case of principles. The principle instruction is a catch-all. If you can't get them one way, hook them in some other way. Well, this is not a principles case, not at all. Every act by each individual person in this case is an independent act. When you looked at the independent act instruction, an independent act occurs when a person other than the defendant commits or attempts to commit a crime, one which the defendant did not know about or intend to occur, and the defendant did not participate in. There's no evidence that Gary King gave anybody a gun, did anything in furtherance of inciting anyone to fire a gun or use a gun. In fact, again, the evidence shows that he was trying to be a peacemaker, that he was trying to calm the situation, get in between people. That's the evidence you have as to Gary King. Again, reasonable doubt. If after considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved, and you must find the defendant not guilty because there's a reasonable doubt. And you have to look to the evidence to determine reasonable doubt. And when you do that, it can arise from the evidence, actually evidence, or conflict in the evidence, or the lack of evidence. Conflict, 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 conflict. That's all you have here is conflict. You've got to weigh the evidence. Were the witnesses honest and straightforward in answering the attorney's questions? I submit to you, Mr. Kendrick was far from honest and straightforward. Did he have some interest in how the case came about? Yes, a number of witnesses did. They were friends with the Robinson family, friends with the Kendrick family. Does the witness's testimony agree with other testimony and evidence in the case? No. It all contradicts everything. Contradiction upon contradiction upon contradiction. Y'all have taken notes. Go back and review them. Look at these videos. The videos aren't to be interpreted by Mr. McCord. They're to be interpreted by each and every one of you. As all four of us now have said, what we say is not evidence. What we say is on the video doesn't matter. It's up to you to determine what's on that video and who is on that video. And I submit to you, if you look at all those videos, you're not going to see Gary King one time. Not once. Another factor is, did a witness at some other time make a statement that's inconsistent with what he or she gave in court? Nathaniel Kendrick. His first statement to the police did not include Gary King at all. He was lucid, able to talk, and was not under the influence of medication to the extent that he couldn't communicate effectively, according to the police officer. You have inconsistent eyewitness identifications. That's throughout the whole case, as to each defendant. Any instance in which the eyewitness did not make an identification when given the opportunity to do so. Nathaniel Kendrick, that first interview, didn't make an identification of Gary King. Look to the totality of the circumstances. Look at all of the evidence. Look at the contradictions. Weigh the testimony of the witnesses. You're the only people that can do that at this point in time. I submit to you that Gary King, number one, was there that night. Number two, was trying to defuse the situation, defuse the argument, broke up the argument or helped break up the argument between the ladies inside, and then came out and tried to get between Mr. Barrow and Mr. Kendrick. use your common sense. Why would a person who's doing that, who's got no bone to pick with anybody in the fight, turn around and start shooting people? It just doesn't make any sense. And you've got to use your common sense. And I submit to you, if you use your common sense and you look at the facts and you look at the evidence and you look at the contradictions, that you can come to no other legal verdict than to find Gary King not guilty of all the charges. Thank you again.